fact-based, because the Commission of Inquiry is a fact-finding exercise. It's to establish the facts as they are. And if you look at the legal notice, you will see that the recitals talk about to ascertain, to establish, to ascertain. But in so doing, the Commission is empowered to exercise certain judicial powers, similar to powers of a High Court judge, particularly in terms of procedure and processes, including the power to summon witnesses, to appear, to produce documents, basically similar to the powers granted to this select committee under the Constitution. So that's my understanding of a quasi-judicial body. But there are other reasons as well. There are other factors. For instance, because of the...
That's fine. I will take what you prefer to the committee, just to give the committee an idea of the government's mind at the time. And indeed, it was the government's mind that the JANNEH Commission would be a quasi-judicial body.
By reason of their mandate and the powers that that a commission is established upon, you can qualify it as a quasi-judicial body. So it's not necessarily the mindset of the government, but it's by virtue of the nature of the commission itself and its proceedings, which is why I would refer to it as a quasi-judicial body.
All right, that's fine. However, I would also like to know whether the government understood it as such.
I certainly understood it as such, and my ministry understood it as such.
And your ministry was the one representing the government?
Absolutely.
And updating the government?
Indeed.
And also advising the government?
Absolutely.
So if you took it that way and your ministry took it that way, it would be safe to say that the government took it that way?
The ministry and the Attorney General is the principal legal advisor of the government.
Indeed.
Yeah.
So then, again, the government then took it to be a quasi-judicial body?
Yes.
Okay. Now, let's go to the setting up of the commission. It was set up on the 12th day of July 2017. Do you have a copy of the legal notice before you? I believe that the Secretariat could aid the witness with MOJ 2. You have it before you? Right. So it was established via a legal notice pursuant to section 200 of the Constitution. Was there any other law considered aside from the Constitution?
The Commission of Inquiry Act, certainly.
Indeed.
Yes, at the top of my head, that's the two I can recall now.
Was the Public Assets Recovery Act considered?
It could have been. I can't recall at this moment.
Would you like to take a minute to think on that?
I don't think it makes a difference whether I recall that or not, but if there are any specific questions about that, please.
Yes, I'm curious because the manner in which the commission was set up is largely identical to what the provisions of the Public Assets and Properties Recovery Act.
What's the year of that act?
94.
Yeah. I deliberately asked that question because I suspected this was the act. It was first a decree, which was later made an act by virtue of the Constitution in 1997, and it must have been the decree or act upon which the 1994 commissions of inquiry were based. So yes, certainly we did look at that at the time as well, and we made certain decisions having considered that as well.
Yes, just to save us some time, some of the similarities in the way the JANNEH Commission was set up and the provisions of the Act would be seen in Section 3 of the Act. I'll just name one and then we can move on. I do not want to belabor this point. It was just to guide the committee to identify the Act. But the decision to have three, to limit the commissioners to three, that is a provision of the Public Assets and Properties Recovery Act, which act is indeed appropriate for such an endeavor. However, I did not see anywhere in the legal notice that it was referenced, and I was curious to bring this out just to aid the committee.
It could have been, I am not sure, it could have been that we were inspired by that act, but I would hesitate to confirm that, because now that you mention it and you mentioned the year, I now recall that the issue was discussed, and it was discussed in the context of which approach we want to take for these commissions, because one approach was the 1994 approach based on this act, where there was no appeals process, if I recall now very well. Now that you mentioned it, there was no appeals process, if you like, against commissions of inquiry pursuant to that act. And under the Commissions of Inquiry Act, which was the alternative, which allowed for aggrieved persons to appeal against the findings of a commission. And we obviously clearly chose the Commissions of Inquiry Act to allow people the right to appeal the findings of a commission. So it was in that context that we looked at the Commission of Inquiry Act and the Public Assets Recovery Act, and opted for the Commission of Inquiry Act.
All right. Like I said, I do not wish to belabor the point. A commission was set up. I'll leave that issue as it is. So, but still in comparison, if I were to compare the JANNEH Commission to its to the other commissions that followed, you would see that the proper administrative and financial strengthening were applied in subsequent commissions, unlike the JANNEH Commission. Is there a reason?
Absolutely. A few reasons. The first reason is that the JANNEH Commission was established under Section 200 of the Constitution. The other commissions that you referred to, which had financial autonomy, were set up pursuant to an act of the National Assembly. So here we're talking about the Truth and Reconciliation Commission, the Constitutional Review Commission, the National Human Rights Commission, etc. So they were established by an act of the National Assembly. If you look at the other commission that was established pursuant to Section 200 of the Constitution, which was the Faraba Banta Commission of Inquiry, you will see that they also, like the JANNEH Commission, did not have financial autonomy. So the commissions that were set up under Section 200, the JANNEH Commission, the Faraba Banta Commission, didn't have financial autonomy compared to the commissions of inquiry, or rather the commissions that were established by an act of the National Assembly, which were more comprehensive, whose terms of reference were more detailed, which benefited from a lot of preparation and planning. Yeah.
Unlike the JANNEH Commission. Any response to that?
I would only repeat my response. We were as prepared as we could have been under the circumstances.
but yet the other commissions benefited from more planning and more comprehensive outlook on especially the administration and finances?
Naturally, they were established by an act of the National Assembly, so it meant we would have had to go through a rigorous drafting process and consultative process, especially if we were relying on lessons learned from other jurisdictions with respect to those kinds of commissions.
All right. It is my view that all the commissions take cue from Section 200. And I don't believe, but you could correct me if I'm wrong, that commissions are never meant, are at any time meant to be dependent. They are always meant to be independent. Please confirm or deny.
The commissions that were established pursuant to acts of the National Assembly were not inconsistent with Section 200 of the Constitution. So let's put it that way. They were not inconsistent with Section 200. But I believe that even where you have commissions established by acts of the National Assembly which appear to have financial autonomy, they're still funded through the government. They're still funded through the government. They get their subventions from the Ministry of Finance through the Accountant General's Department. So I don't see a material difference except in the management of those resources. I think it's a question of accountability in the end. In the case of the JANNEH Commission, because the Justice Ministry was the financial conduit, if you like, there will be some accountability on the part of the Justice Ministry for the monies that were expended in the JANNEH Commission. In the case of these other commissions established through an act of the National Assembly, they are self-accounting commissions, so they answer directly in terms of their accounts to the Accountant General and Auditor General.
And which one would be more ideal?
I think I have said right from the start that the higher or the greater the degree of financial autonomy, the greater the perception of independence. But if you ask me, from my personal perspective, independence for me means operational independence. The ability to make decisions that are based on relevant considerations and not irrelevant considerations, and not to be subject to the direction or control of any person or authority. For me, that would be independence.
Again, let me put it simply. Which one would you opt for if given the choice?
I'm not sure I have a preference for either, so long as operationally the entity is exercising its authority without being subject to the direction or control of any other authority or person. To be honest, I do not care where the money comes from.
Okay. All right. You had earlier brought comparison between the judiciary, the National Assembly, and the government. And I was tempted to weigh in then, but decided to reserve myself. But I do want to set the record straight as it pertains that issue anyway. You see, indeed, the way these three institutions are set up, you know and I know that they're set up in a manner that each institution sets a check on the other. Now that is natural. It doesn't in any way interfere with the administration of the other. the president and his ministers are free to do whatever they are to do in the context of what is provided for by the Constitution. The National Assembly, likewise. The judiciary, likewise. And from what the Constitution provides for a commission of inquiry, you and I both know that when interpreting these laws or when reading these laws, we don't only read them from a naked eye point of view. There are contexts that need to be applied. There are principles that need to be reckoned. And just like one cannot interfere with the principle that the judiciary is inviolable administratively by the executive or the National Assembly, one has to come to terms with the fact that commissions of inquiry are meant to be independent fact-finding bodies that essentially are deployed to weed out